Single bench matter.
Such a crowd for mentioning.
Yes,
Please pass on all the memos. Please pass on.
Here, this is a single bench matter. That is a problem. Here, the bench it was listed long back on matter 6/9/24 before the Honorable Justice G. Satpathy. He was concerned, so that is why I could not take up. It was assigned to some other bench. When it was listed, could not be disposed of. Thereafter, that bench is not sitting, and now it is sitting half a day or 1 day in between the weeks. And the office is in confusion to list it before the assigned bench, the present assigned bench, or the bench which was allotted.
That's an administrative decision we'll take.
No,
Don't worry. You just write a letter to the administrative
I
side.
did it. Thereafter, I have come.
They will place the file with me. Don't worry. And that's my standing order. Whatever the files are there for administrative side, you have to place it on the same day.
I made a mention to register. He said that I will see. It is not listed today. Any batch available, your lordship, direct to list it.
There are many litigants whose matters are pending.
No,
only this litigant has been able to take the services of yours.
No.
That does not mean we will do it. Don't worry.
I was not giving that service also, because it is a 6.
Well, it's a service. That's a noble service you give.
I am also waiting till like the heading.
6/9. That's a good service.
No. 6/9/24. This matter was listed for.
It will. Please give it. It will be placed before me in the administrative side. I will do the needful immediately.
6/10. That is why I make a mention. Otherwise, I won't have mentioned.
Don't.
The bail matter was listed on 6/9/24.
Sir, just give it. It will be placed. Tell the registrar to place the file with me.
Yes.
You need not have to mention. Unnecessarily burdening the court. Don't worry.
Another matter which the tender matter, your lordship had called for that record.
Please
that
pass on the slip, sir.
Called for the record on Monday, and I requested to take up both the matter together. But order has been passed in one case. The order has not been passed in another.
Oh, that is the same thing, sir. Don't worry. It will be covered. Don't worry.
Yesterday,
seniors should not mention. Seniors should not mention.
That is why locally I have never applied for it. I have never.
That's why I said no. You have acquired a tremendous amount of practice experience.
That is why I never applied and I have never become. So I have that privilege of mentioning.
After launch, yesterday I have mentioned this matter.
Please pass on the slip.
Intentional that the section is not sending the record back.
Why not? What is this? Why it is not sending? Please give. Why it is not sending? Seek an explanation from him.
Pardon to mention, your lordship. Your lordship, an urgent matter related to CAT recruitment, your lordship, which will be
Please pass on the memos.
The matter is listed today.
If you go on mentioning, we will not be able to call the matter. Pass on the slip. We'll take care of that. Please pass on. Please pass on. Ask that why it has not been.
Yes, sir. I'll contact. Item number 1.
Yes.
Why? After such a long discussion.
What has pointed out yesterday.
So cases which they have not disclosed. Lordship, once we have given it.
Sir, we will not allow to steal the march from the corridor of the court.
So it's a case where they're trying to take a chance, either in the writ appeal or here, because there are pending. If your lordship would see that table. Each of the petitioners were before your lordships in several cases. You have given it by way of a table.
And they have not disclosed a single instance of those.
Neither the writ petition nor the writ of.
No.
As per my instruction.
And those pictures which are pending before the learned single judge, that is mentioned here.
That is mentioned, that is vis-a-vis another year.
And
Page 3 of my writ petition, my lord. That is the number of raised petitions they have asked me to disclose. I have already disclosed in this edition.
Show us that you have disclosed. Show us page 3 of your affidavit of writ petition. Yes.
That is what.
Page 3 where you have mentioned.
Yes.
In the writ petition,
Mr. Abhyas sitting,
I do not find.
It's that these restrictions are pending before the learned single judge which you have mentioned. Where these petitioners or parties before these cases, you have not mentioned, that is what.
That is my.
You are
I
required
for an
to-
apology, my
So
lord.
that's the apology.
Before-
Is a conscious act of suppression. Conscious act of suppression. Those have already been disposed of. And you know that the order may have been passed against you. You have consciously suppressed. If that is the position, then my judgment is staring at my face, where I've imposed a hefty cost. I will not. And you know the decision of the Supreme Court that the suppression is one of the greatest, may I use the term, the crime for. No, sir, we will not permit. At least I am not permitting. Let them understand that if they do not come the court disclosing all the material facts, then let them face the consequences. Let them face the consequences. We will not. Sorry. Sorry. No, sir. Brother, I intend to impose costs on all these litigants. Where the suppression of facts.
If I have also got your lordship. 181. The silk of food. First one would be A.D. Sharma, 2008-12 SCC 481. Relevant paragraphs will be 38 and 39.
That is referred to in this case. Sir.
My lords. And the other one would be Dilip C, paragraph 7. There is an entire list of cases. Para 7 would be relevant in the context of this case. 2010 to SCC 1144. I've got my own judgment from Calcutta that also have passed through. Para 28. Paragraph 12. Paragraph 12, wherein my lord has taken note of the Supreme Court judgment. That would be page 3 of the Calcutta High Court. Under para 12, my lord has taken note, has said that if something is based on falsehood, he has no right to approach the court. He can be summarily thrown out at any stage of the litigation. It's referred to all the judgments. K.D. Sharma. Another judgment of my lord from Calcutta also I have got. It's in injunction matter. where my lord has said that if my lord, if it is not if they don't disclose, then it may be injunction being given. It's in the civil side. My lord is also referred to similarly. That would be 2015 SEC online calculator 6015.
I'm bound. Unless you convince me that I was wrong.
All disclosed. And on the contrary, these were
Sorry.
the facts.
Sorry.
My lord, we have submitted me. So those not.
So, no, it is not you personally, sir. It is a litigant. You are simply representing the litigants. It's a statement made in the pleading by the litigant. He is a deponent. He says on affirmation that all those facts are true and correct. If he who suppresses the fact, then it is he who has to suffer.
And you have rightly given in the certificate that as per instruction received. So you have drafted this petition as per your instructions.
So why you are taking personally on you? This is not a
Personal,
case on you, the case of a litigant. So let him face the music. No. On the last, on the last
taken note of all.
Oh, I understand. I told him that I am bound by my own judgments, but
In the para 39 of K.D. Sharma, which in fact I've always recited with this, I think that's the most beautiful portion in this, which says that if the
The
applicant
lordship
does
has
not.
quoted that.
39. It
I have
says that
38 and 39 are
that's the
quoted.
beauty of the court to
Oh,
protect
that is
itself.
what I have said,
Yes,
madam.
No, the.
I think my rhetoric was also to some extent.
No, I somehow this aspect I have argued so many times, and that particular paragraph always appealed me.
That's true. I have also in my judgments, have you seen those judgments which I have? I have also quoted in those lines. That was a case of a fraud, actually. I have said that it is a settled law that if a case of a fraud or a misrepresentation of such dimension is discovered, the very basis of the order passed by the court is affected. The court can recall its order provided such fraud is clear on the face of the record. It is no longer a centigrade that the fraud and the equity cannot dwell together. The fraud vitiates all solemn act. If the fraud or a coercion is alleged in the petition, it must be set out with full particulars required under Order 7, Rule 4 of the court. Since the fraud affects the solemnity, regularity, and orderliness of the proceedings of the court have inherent power to set aside an order obtained by fraud. Fraud is an act of deliberate deception with design to secure something by taking unfair advantage of another, and the fraud one gains at the loss of the another. There is hardly any quarrel to the aforesaid proposition that once it is successfully proved that an order is an outcome of fraud, the court shall recall its order as such. Order cannot be said to be a legal valid and in consonance with this. So I have already said so. This is on a different.
My lord has taken note of all.
No, I have taken everything, but that was a different perspective. That was in case of a fraud. Anyhow, my flow of thoughts have been disrupted. What I said?
Item number 2.
Yes.
I have filed an application for intervention, my lord. In the meantime, I have been selected as L1 in the tender. And I have been awarded the
Work order.
I have deposited the APS, my lord. Hence, I may be permitted to allow as opposite party.
So that application as who is for the petitioner? You are for the petitioner. What do you have to say about it?
In fact, let's say
Tell me addition. You wanted
state to file a counter lawsuit.
why? You are the dominus litis, sir. It's your writ petition. Somebody wanted to intervene in your writ petition.
I don't
Will
have.
you not be heard?
No lawsuit.
State is they are
I have no objection in the.
so there is
That's right.
by consent.
I.
By consent of power.
But
Have you served him a copy already?
I got,
no.
no.
Give him, he's giving a consent. Give him here and now.
No, I have given the copy of intervention to.
Intervention I wanted. You have given.
Yes, sir. And,
You have no role to
so,
play.
no, I have already been served.
Oh, they have no role to play. They are
Yes.
as a party respondent with you. What is this application? IE?
Item number.
Like B,
Malo,
like B.
plug.
Yes, this is an application at the behest of a non-party seeking their
There are other 8 matters are there. Let's see. On same point.
whether he has sought for addition in all the
In
matters.
one case, my lord, I have filed.
In this case,
In this case and in another case of the list.
please give that so the same order will be passed there for addition.
They are
And
not-
the rest of the orders, you are not there, so you will not be.
They are not on board.
That is not in the board, my lord.
Oh, that then we
That is
do.
not in the board, but my learned friend is supplying the list.
So that will be listed on the other day.
Let-
List those matters. Yes.
Let's say along with this
They-
matter,
they-
one affidavit, let's counter.
Yes, no difficulty. They'll let them file.
They
Yes.
all emanate from one.
One, same
One.
cause of action, lordship. Same point also. all this.
Item number 3.
List them- Give the list along with that.
That's separate.
Yes. Call the item number?
3.
Entry matter continues.
Yes, please.
Let's see, entry matter.
I do not know. What is that interview?
Entry matter, they are lordship.
Already there?
They are already.
Oh, then
That's the concept.
till next time.
Correct.
Yes.
May I please go? This land acquisition matter,
Land acquisition matter, then why it has come to me?
the villagers, all villagers are before my lord.
So that is, I have a roster
My lord,
of land acquisition.
let me finish, my lord, let me submit. My lord, what is the
First,
case?
let me ascertain my jurisdiction. Then you will make the submission. Whether land acquisition matters are within my roster
No, my-
or it is given to some other bench.
It is in the form of PIL.
It's inside of PI.
Oh,
And you said all the villagers are before us, but 29 villagers are.
49 villages there,
so there's a small village according to me. It consists of 29 persons.
29 villages. My lord, the Mahanadi Coalfield issued notice to them to take the benefit and go away. But they have constructed the building residing there. The no compensation is being paid to them for the construction made by them. Because of the ground that.
So
no-
PIL.
My lord,
So PIL.
yes, ma'am, we have some of the petition, I have submitted the judgments also, page 118, my lord. Or page 118. I have
Yes.
submitted the judgment.
What? What
Of-
judgment says?
Of the collector, because after the.
I am talking about the law on a PIL, whether this kind of a case comes within the purview of PIL. I am just asking you.
My lord, I am submitting that. The collector decided that you are not entitled.
That is not necessary. That is not necessary. You please tell me that a government have utilized your land
Yes.
or a land of a village
My lord,
without initiating a disciplinary, without initiating a acquisition proceeding, without paying you a compensation. Does it come within PIL? Sure. Facts are undisputed.
my lord.
Whether it comes or you can approach the writ court,
Yeah,
the normal writ court vindicating your grievance. What is the public element which is involved?
yes, my lord, that.
How you can represent as a social for the benefit of a social, economical is the suppressed section of the society.
No, my, it is the case where the petitioners are.
I know about the PL a little bit. I just wanted to enhance my knowledge if you can.
Sometimes I.
The PIL which originates, it says that any public spirited person, he can come and espouse the cause of a poor, economically backward, those who cannot approach the court, marginalized section of the societies for their common good.
Yes,
And if it appears that their fundamental rights have been infringed, then in that event, there is no difficulty. One can espouse the cause
yes.
for those persons.
That is-
You are a peoples who are directly affected.
Yes.
Can you be said to be, are you not a personally interested person? Can you settle your own score through PIL?
My lord, may I submit? My lord, some of the petitioners approached my lord. The writ court directed the collector to take decision in this.
Correct?
The collector took the decision that you are not entitled to eliminate.
Correct. You challenge it
That
in a writ.
that is in respect of some of the cases I have cited before.
So what? Then once you have approached, then you'll have to go and approach the writ court challenging the order of the collector that this is wrong. It cannot be done. How the PIL lies? I am just asking you very simple question. I have taken one matter so that I will state the law of the PIL. I have found that these kind of a personal issues, private issues
Yes.
are settled through PIL. Yeah, this is a very unique thing which I have noticed.
Here the villagers have approached my lord.
Sir, you challenge the order of the collector. The collector has wrongly passed the order. If you think, you challenge it. Who prevents you from challenging?
No, my lord, I am saying that there is no fuel. There is nothing else. The persons are being rehabilitated there. But still then the MCL is taking steps to evict them.
So what? Then you go and approach. If your statutory right, if your fundamental rights are infringed, you can definitely go. This is your personal right which is given. What is the public interest involved in it? It's your personal interest which is involved in it.
Villagers are.
So what? Order 1, Rule 8 of the Code of Procedure is introduced for that when there are a numerous number of the applicants which have a common interest. They can definitely take a plea. It's a class action. It's a representatives litigation. Go file it.
With that,
File it. Why PIL?
with that,
What liberty? The court will assume the advisory jurisdiction that what you do and what you should not do.
But to that extent, I am not something that, but I
No.
withdrawn the letter.
It is up to you. That's your brainchild, son. Your baby. You have to nurture your baby. Why the court will give you an advice what to do and what not to do? You are the best person to take a decision, sir. Take a decision. If you pursue, then you'll have to satisfy me whether it PIL lies. I do not know. Show us that the PIL would lie in this situation. I will be no difficulty. I am still, my mind is open.
With a request to
Or withdrawal. Stop the withdrawal of the.
Four. Item 4. Item number 4.
Yes, sir. Nobody is here. Jeevan Jyoti Mohanty. Anybody knows him? BP Mohanty, A Mohanty, and M Mohanty. You know them, madam? You don't know. They are the practitioners here and you don't know.
Very new year, Lordship, 2019 enrollment number. He's given a mobile number. I'll contact him, Lordship. It will be passed.
Passed over.
Right. Item number 5.
Yes, sir.
To seeking admission into BR program, the government college.
What is this BR program?
BR college is course in the engineering college.
BR.
BR.
Bachelor in architecture. Bachelor degree in architecture.
So, BR. Oh, ARC. Oh, sorry, I stand.
Running was 38 and 39. The government.
Is there any competitive examination for that?
Madam?
Is there any competitive examinations conducted by the state for that admission? No, I am just
Money.
Bachelor of Architecture is also like a BTech or
Madam, BTech.
akin to it. So there is a competitive examinations. So what you are challenging any action?
Running for 39. Running for 39.
What?
The government has allowed the closure of that program, though infrastructure is there. The student that due to closure of that student and post student are not getting seats in government colleges. So that was my answer.
That is a decision of the government because they have discontinued this program from the year 2020, 2021. Now we are in 2025. What admission? 5 years have elapsed.
That's not admission. Let me access to your website.
Challenging the policy of.
Progressive closure of the BR program. What is this?
Can have a class for annexure 5 Miller. That was previously being imparted in that particular institution, Miller. Now the institution at annexure 5 phase 38 has taken a decision and communicated to the government that it may be discontinued for lack of staff and infrastructure. Therefore, government has discontinued. Now,
What? Why you will study in a particular institution which does not have the adequate manpower, adequate facilities, the adequate infrastructure? What you will do?
My lord, still the program is continuing. Some students are now.
No, these are all the old one. Prior to that, must be doing it. And this is what in 2020 they have written and they have discontinued from that year.
My lord.
What is the duration of the course?
5 years.
So definitely who's
Now
maybe at the verge. In 1990 must be at the verge. So this last batch will go out.
now 3 batches continue.
I understand. He wanted to be admitted. That is what I.
he has filed a PIL. He's a retired person of that institution.
PIL for what?
So reintroduce.
So you started as if wanted an admission and no admission is granted. Sir,
Kindly consider, madam.
sir, I do not appreciate the manner you started, sir.
Kindly consider.
I have a strongest of faith on the members of the bar because what they say to me is all sacrosanct because I believe that they will not say anything which is something in a distorted manner.
For the sake of our students. please
Sir, but
consider.
you are not supposed, you should say that it is a PIL. This is what you say, my admission, I have not been given an admission. If all the members who are here,
My lord,
your first opening sentence was this.
my lord, please kindly consider for the sake of poor students, my lord. Kindly consider that.
Sir, what these students will do if the college does not have the infrastructure,
Must
they
have
do
the
not
infrastructure.
have the faculty, they do not have, they
May
wanted
college say,
to
ma'am.
close.
May
What
college say-
more?
May college say, my lord, I may kindly allow to college say the same. Because government has given money, running pace, 18, my lord. Government has given 0.7 crore to that
When the
development.
institution
Government
itself-
also,
Mr. Sir,
my lord,
when the institution itself has said that there is no faculty available there to continue with the course curriculum, then can we force
no,
the government?
These are all
to-
2015.
that
You are talking about the disbursement of the amount in 2015. Sir, we are talking, we are in 2025.
running page 14, my lord, this
Sir, 18, you said that you come to 18, the government has given. And this is of 20th of, I do not know, maybe July 2015.
government is also
So
interested.
they were running that program till 2020.
Running page 14 also, faculty members are also there.
Sir,
More difficult.
now it does not
Right,
mean that
consider.
those who were there in 2016 will continue. They must have gone somewhere else.
Like government also.
No, we
My
can't.
lord, for the sake of poor student, my kindly consider.
What is this kind of a PIL, brother? No, sir, it's a misconceived
My-
PIL. I think today is a day for a dismissal. It is started with that.
No, in fact,
Ah.
kindly.
No, sir, if this PIL is entertained, I think no PIL on the earth can be dismissed.
Kindly allow to that college to.
What are you talking about? This is the PIL.
For the sake
Nothing.
of poor student, man.
What course today? Sir, please, education has some values. Sir, what we are producing a good citizen, an intelligent and knowledgeable citizen for the future. And if this institution who does not have the faculty member, this institution who does not have any infrastructure, no facilities, if they admit what students we will take out from
I
there.
humbly pray.
No, sir.
The college may say, my lord. They may college may allow to say, my lord.
No. College have said discontinue. What more? What more?
They should.
No, sorry.
I have filed this with the amendment.
No, sir. No,
They
sir.
should file their
No, sir.
counter
No, sir.
on this regard.
No, sir. No, sir.
For sake of the poor student, my kindly.
No, sir. This is absolutely, I would have appreciated. Please, what is the fundamental right? Tell me. What is the fundamental right you have? Is there any infringement of the fundamental right? Tell us. There is no element of the fundamental right involved.
My running case 19 and.
Even a right to education will not be extended to you.
No.
That's a BR.
Very valuable.
More than 18 or 20 years of age.
Very valuable technical subject.
Sorry, we can't.
People are
We
not
can't.
getting seat, so they are suffering value.
The instant writ petition in Sir, it's a college who has to consult. Sir, it's not a government. I have said, it is not a government who has discontinued. It is what the college said that I can't, we don't have the faculty members. It is a college who has to take a call. If they have the adequate amount of the faculty members, they will do it. Sir, when you come up the court, please look at, if your own son is.
The case may not report to the last order. Already 7th of July 2025, order number 1.
Yes,
Yes.
mining officer and Tahsildar.
I've received the instructions. So, Your Lordship, may I-
What instructions? It's a law point.
Your question of.
Yes, on question of law also, Your Lordship may kindly see 51(4). 51(4).
Have you saw a copy?
This instruction, so. (51)(4), Your Lordship may kindly see. And this is not a penalty, but a royalty which has been asked. for.
How do you impose
Lordship
a
may kindly see.
royalty without a lessee? You can't impose rule 32 kindly see. Royalty is only on a lessee or a permit holder.
Where is that judgment? I
Another-
had an occasion to read it, whether the royalty is a tax or not, that 5-judge bench.
Your Lordship
This
may
is
kindly
a-
see this.
Can't be a-
51(4).
Not settled,
Can't be a royalty.
Royalties,
Kindly see rule
not a
32.
tax.
not a tax.
Not at all. Kindly see rule 32, unheard of.
Your Lordship may kindly see 51(4).
You are
The language.
compounding,
The language of the statute, Your Lordship may kindly see.
justifying something which is unheard of. Kindly see my lord, rule 32.
51(4), Your Lordship may kindly see.
No, question is that whether the Tahsildar can do it.
And
The
here the mining officer has
mining
done.
officer has done it, but he can't do this. It's a 51. If you are saying that without any permit, I have stacked something, then you will have to lodge a complaint before the court and maximum fine. the
that-
court-
Oh, where is a
That is
Annexure
with
one.
respect to penalty. Your Lordship may kindly see 51(4).
Our observation. In,
Is a penalty.
It's a penalty.
Where is the order?
This is not a penalty. Annex
Just
1,
what?
Your Lordship may kindly see.
Where is the order?
Annex
Page-
1.
Page 21. So misreading the whole thing. Kindly see page 21. Let him then satisfy that I am a lessee.
Penalty also we have imposed. 5 lakhs.
Sir, royalty you have already imposed, then you have also imposed a penalty. We are concerned with the penalty, last one.
Royalty also he cannot. I am not a lessee.
That's whatever,
Right,
sir,
right.
whoever royalty you have imposed an additional charges for the sand.
Right, man.
But what about the penalty of 5 lakhs? How can you impose? That is what the question is. Look at, you have done it.
Yes, yes. Penalty, I.
So it is a criminal offense, if I correctly remember, he was referring
yes.
that provision.
You
And
are
it is a
right.
court who can impose either the punishment or a penalty or both.
My lord, so far as criminal offense, the.
But there is no
51(1)
provision in the rules regarding the penalty to be imposed by the mining officer.
Yes.
So how can it,
But Your Lordship may kindly see 51(4).
please show us?
51(4).
He is quoted. He has
Yes,
quoted in.
It is quoted in the.
Is a minor minerals concession rules?
Right.
Yes, 2016.
Yes, 2016,
Month.
51,
51(4), subsection 4,
Sub-rule.
yes.
and sub-rule 4. Wherever the person wins without any lawful authority, any mineral from any land, the Tahsildar or the mining officer or deputy director or divisional forest officer,
My learned
As
friend is
the
reading
case may be.
51(4). I'm sorry. My learned friend, I'm sorry. I'm
He is
just
holding, he is holding a prior to amendment book.
So he can't read that. 2016.
what, 2016, Odisha minor minerals.
Mr. Sir, after amendment, there is an amendment. That word Tahsildar is omitted.
Tahsildar,
In 2022,
yes.
23.
they have this
Yes.
book. They have this book.
Sorry, I'm holding it from
Ah.
2023.
Ah. Your.
I'm sorry, I
instruction-
stopped him.
Brother.
is correct. Ah, Here it is.
I don't know. Let us. Yes, read, sir.
Whenever if the person wills without any lawful authority, any mineral from any land,
the mining officer or deputy director or divisional forest officer, as the case may be, may recover from such person the mineral so own, or where such mineral has already been disposed of, the price thereof, and may also recover from such person rent, royalty, or tax, as the case may be, for the period during which the land was occupied by such person without any lawful authority. Now the unit is closed. Closure order is there. He has challenged it in a different writ petition that your lordship will find at page 126. Sorry, ma'am. That is a page.
Now stacking, you dragged the word stacking,
Yes, it's there.
which you have used in the impugned order. Would you mean to correlate that to winning of mineral and disposed of otherwise?
So it's there. You have admitted it. Whatever person makes.
I do not know, it's
Out of the context, we are ask this question, maybe a very irrelevant or a foolish question, but is there any permission or the license to be granted to run a brick kiln if they do not excavate the minor mineral? They can purchase it from a person who has a license to excavate. Can he not purchase this? Is there any bar of dealing or purchasing those minor minerals from any lawful or a license holder?
Then he has to produce the materials before the authorities.
No, it is, you could have asked for if there is any voice or if there is, only stacking does not mean somebody may have bought it. So that you can make a brick. I'm just asking, I do not have any idea about it. That's why I use those two terms, irrelevant and a foolish.
Then your lordship may kindly see the page 2 of that instruction, page 3 of that instruction. The mining officer visited the spot.
No, that is reflected in your order also that you
Yes.
found stacking of the sand. It's not now.
Caesar
That's
has
a
been prepared.
alert.
Yes.
That's why I asked this question. Is there any bar of buying a sand for running a brick filled unit without excavating? I do not have a right to excavate. Can I not purchase the sand or minor minerals for running my factory as a raw material? Can I not purchase the raw material? Is there any bar in the trading of? No.
But the
I'm
unit,
just asking.
the unit is already closed.
Or query is
For
already given for the captive use or not to be traded or to be sold in the market.
In absence of any presumption, he could not produce the service. The very presumption in the statute.
Oh, he did not produce any valid documents.
And moreover, this order is also appellable. The lordship may kindly see 46. And that is my another.
Not an absolute bar. So 26 can be entertained
Yes.
if there is a manifest injustice apparent on the face of the remark.
I hope when Mr. Das will be this side, he will cite HON'BLE and he will cite the Calcutta District. And when Mr. Das will be this side, he will cite definitely Calcutta District.
I can concede to the extent that 51(4) doesn't speak about the penalty. But so far as royalty, that they have.
No, I'm on presumption. Unless statute gives you this scope. The reverse burden, like taxation statutes now provide. Earlier it was not there. The assessing authority has to prove the sale. Unless it proves the sale.
How you have
Submission-
sir? How you have stand those?
No, in fact, I have said, they are all supported by, no, they are all supported by documents. Permits, I have, the problem is, the day he came to this spot, the same day he has drawn this demand, the same day he has done everything. He has not given me a so-called notice even. He has not given me any opportunity to produce any document.
Document.
But they are part of the restrictions, Annexure
22 series.
Annexure 22 series, page 148 onwards. These are all stats in 2016. It's an old unit. I have my setting criteria. I have my EC. I have my consent to operate.
Since when
Whole-
it is closed? Since when it is closed?
Like very recently it is closed, page 124. But I am also commenting on that issue to reopen it. That's a different matter. But page 124, they closed it.
So this is on 2023 and page 148.
19/12/2024 closure order. Page 134. 136.
No, you are relying on annexure 22.
22, yes, sir.
This is what is the book number.
Well, they are all permits for transportation. Page kaha?
What is this? What is permission is?
Beg pardon.
CL. CUL.
Yes, Miller, CM, cubic meter.
Cubic meter.
Right.
22.
22 cubic meter, yes, quantity permitted. But lot many permits are there. But I can demonstrate it. I can show it to the authority, provided you give me a chance.
Or
From
any
2000
other persons you have transported
Yes,
with permission.
yes. I have purchased it from this.
You have shown that from leaseholder you have
I have
transported.
purchased it. As my lords were observing, I purchased it. I have been operating since long this unit. It's a bricklin unit. Merely because I have filed cases against you, 2-3 repeats, suddenly you came to my unit. Lord, you have done all these activities and imposed this 14 lakhs on me.
Yes, sir. All is there an opportunity?
Lordship may kindly see those transit pass also. Even
That we decided here.
159.
Let it be an opportunity.
all the transit pass have been issued in respect of another unit, stone quarry, and this transit pass has been given to another unit, my lord. Your lordship, may page 149. Name of the query lease.
Yes.
Your lordship may kindly see that stamp over there. Nisakarpur Baitarani River Sand Quarry. The
Yes.
name of the petitioner's query, your lordship may kindly see.
What may your friend? He
Raja Bricks.
sold. He is the vendor. My learned friend is misreading the entire thing. He has sold it to us
Purchase it.
in the sake of opposing. How are you reading all this?
Purchase
The
receipt.
leaseholder, sir. Leaseholder, what will you do with the
Opposing side. What
mineral
is this?
extracted? You will sell it, of course.
These are all
For end use.
leaseholders who have sold me.
For end use, you will sell it. Why a person takes on lease? For
But
his quarry?
there is nothing on record to show that he has
How can
purchased.
I-
That is what I am trying to say. My transit pass has been issued,
Date was not given any.
How can I?
and these are prior to the closure notice.
Obviously.
These are prior to the closure
Suppose
notice.
if he has already purchased and there was a closure notice which is given, he is unable to utilize those raw
But
materials.
regarding,
It will remain there stacked.
my lord,
He
regarding
can show that I have
purchase,
not utilized.
my lord, regarding purchase, there is no document. And that is what I am trying to say. At least we would have produced any invoice to that respect.
Give him an opportunity to produce. If he has produced those documents, if his vendor has given him the document, the vendor must be, will definitely produce those documents before the authority. And given the opportunity, if he cannot produce, impose, no doubt about it, no difficult, impose. But suddenly, You can't.
Same day, same day. Not a single day thereafter.
And they have proceeded on the basis of the complaint. And on the date 13/5/2025, when the officers visited that spot, he was very much present. Those photographs also I have given, my lord. Those photographs are also there. He was present. He could have produced those documents. No, these have been validly purchased.
In a commercial world, the rivalry is always there.
Have you ever seen any authority visits a spot and imposes penalty? In taxation matter, it happens.
That the law permits.
Law permits.
Somebody cannot carry the old register with him always behind his back, and whenever you arrive, you will show it.
Not so innocent.
No, I understand. I understand, my lord. Not so innocent. But fact remains that look at the conduct of the officer. What is he doing?
You have a law, sometimes in your favor, but
No, my lord. We have all lawful documents. Lord. It's not like that. The officer is he is after me. That's the problem.
Why he will have any
Yes.
personal vested interest over
use the word antagonist. It's very difficult.
I stopped it. I controlled my tongue, my lord.
me too, my lord. Because I have already produced the
One
instruction.
example is very apparent. If you do not have the ability to impose penalty, that shows that it won. That shows its appearance, that was with a closed mind. So give them an opportunity, let them produce, if it, once again, order what is on.
And only I can pray, my lord, your lordship may fix up a date that so that the authorities, he can appear before the authorities on a particular date, he will produce the.
100 PM has become more than the mining officer.
No, that is.
I exclude me.
Because the experience is that sometimes I did not get a notice, I was not given, that will really.
Fine.
So if the date is fixed,
No, I said in a lighter way.
then it's better so that you can go.
I said in a lighter way.
When a date.
As your option be this.
Be
Be it 28th of July.
at 12 noon. 12 noon.
28.
12 noon. Before the mining officer.
Before the mining.
Mining officer in charge.
No, the present mining officer, Baleshwar.
Is.
Grateful.
Look at the name of the officer.
Raja's question.
Item number 7.
May I please allow? In the petitioner's ounce of licensing matter, during validity of his license, the shop was made functionally rented house. The house owner rented house matter. The shop owner, the owner, he denied to extend the agreement. I was impelled to file an application for shifting. For purpose of shifting, I filed all documents along with the statutory fees, that is 2.5 lakhs, to the authority, my lord. Lordship, that you will find annexure 1. Thereafter, as per the rule, it has to be initially inquired by the inspector of excise. Then he will submit a report to the superintendent of excise. Superintendent collector will go for public notice, where objection will be invited from the general public of the proposed area. Thereafter, the collector will recommend it to the commissioner for shifting, as the commissioner has the power for shifting. Rule 53(5). Lordship may see, on 5/8/2024, I submitted my application. There was 3.5 months delay at the level of inspector of excise. Inquiry report is submitted in the month of November. Thereafter, in the month of February, it should be annexure 6. The collector sent it to February to the commissioner. After 4 months, that is impugn note at 7, in the month of June, the commissioner asked for me to deposit because there is a shortfall of MGQ. Matlab, my application could have been considered within the excise year. Lordship knows 31st March is the last date of a particular excise year without considering, and they kept pending at the level, and finally they now impose penalty with fine, my lord, because my license was valid till 31st August. Thereafter it was not renewed because the shop is closed. Once shifted is allowed, then I will take the new license. They will grant the new license at the proposed place. Without doing so, my lord, my application was kept pending near about 10 months. Now, in the month of June, they say you could deposit with penalty. If you notice at page 23, still his application is pending. The rule 51, it relates.
Take instructions.
The law points. But you were not physically evicted from the premises. It was
No, because he had to renovate the entire building, demolished. Thereafter, otherwise I was impelled. Nearby, I arranged, I submitted the land particulars, everything with the statutory fees to the authority. Well, the 5113 says the application should be dealt with within 5 months from the date of submission. At best, it could have been considered by end of January, my lord. Then I would have lifted my NGQ.
Yes, what you say, madam?
Lordship have to take instructions. Because here he has shown annexure 1 says that the validity was up to.
For shifting has not been considered as yet. I think you have corruption.
Your lordship means the license shall remain valid from one.
He activated the closure because of this.
His license validity under annexure 1 is
Sir.
still. Yes.
Sir, he says so. But he has already intimated that the landlord has refused to renew the lease, so he cannot open it and cannot occupy that.
Lordship have to.
He has given so that the closure notice has already been given by.
Yes, madam.
An
I'll seek,
application was made, pre-shipped from it.
I'll seek instructions, your lordship, shop was open, not open. What?
No, I have reflected in my application, my lord. Shop is
Close,
closed.
your lordship.
Annexure 1, it has been, I have mentioned. Madam, you can see, there's very much mention on application, madam. Page 12. Last table, last line.
So lordship, I'll seek instructions as to what was the reason for the delay, if at all there is reason. It did come after 1 week, your lordship. Next. On 16th, your lordship.
Okay.
Item number 8.
On behalf of Mr. Rekha Sarangi, I'm praying for the urgent matter.
To replace the memory mill last occasion, let's direct it to submit the decisions. I have prepared it more.
I will kindly put it every date of the next week.
There's no stay.
That's it directed me to search for the decisions. I have sought and I have got a decision delivered by a lordship under the previous Calcutta High Court. I have got it.
I may change my view. The person becomes wiser by passage of time. Maybe that I have become wiser now. Oh, yeah. Can you maintain a repetition of such nature? Impossible. Have you passed the order of eviction?
Yes.
In an accommodation was sought on behalf of the previous.
Item 9.
Item 9, your lordships, I have a mighty lease and however, your lordships, under the 2007 rules, I will have to have a trading license. I had a trading license for 5 years. It's expired on 21/5/2025.
Expired what?
21/5/2025. In order to apply for the renewal, I have to submit a certificate called Mining Dues Clearance Certificate. This Mining Dues Clearance Certificate is granted by the Director of Mines. And the renewal is granted by Deputy Director DDM of my concerned DDM. However, your lordships, whenever the mining dues issue arrives, generally the information comes from the Deputy Director of Mines, because he's the immediate person, administrative authority who's looking at my work.
Subordinate to.
Yes, same department. Now what happened is my license renewal application has been rejected on the ground that the MDCC has not been submitted by me. But the problem is I had applied for it in January and they have not taken a call on my application. That's my first point. However, we made our own inquiry, and to our understanding, if there are any dues, one of them was some 67 lakhs, 62 lakhs towards the, I would not say exactly the mining dues, but anyways, we have cleared that. If we have taken the averment, shown the document. Then to us, two other factors might be there. One is the stamp duty, which is an issue pending before this court, and there is a stay order for all the lessees. So we have also annexed that. So that can't be a bar for me not to grant this.
What is that?
Your lordships, they made an amendment in the stamp duty and made a stamp
Duty Act.
Yes, and made a retrospective demand over all the lessees.
Means those where the lease deed has already been executed.
executed. And that has been stayed, your lordships. And that's a matter which every lessee is there before this court. In fact, I am also the counsel that matter. So we stayed in that order also, we have annexed. Your lordships, there is another issue is, we all need an EC to run our lease. And the EC has a limit. This is your production limit. And if you cross that production limit, what happened is that was considered as a violation under the Mining Act because of that judgment from the Supreme Court. But the amendment has been made in 2021 to the Act, which says that the unlawful authority, I mean the 21.5, section 21.5, from where they are gathering these powers to levy royalty or any kind of penalty on us, has said that no, unlawful authority means only if you do not have a lease over that land. They've clarified. So the basis of the judgment has been taken away. This demand on the EC had been made on me in the year 2023 after the amendment. However, I have challenged it before the revisional authority in the central government. And we've made all these fair disclosures also in this writ application. All that I'm saying, you don't take a decision this way or that way whether I should be granted. And your left hand doesn't know what your right hand doing, and you say that I will not renew. Now, what has happened? My entire business, everything has stopped because without a license, I cannot do anything.
Why can you, how you can sit over that particular granting that no use certificate?
Let's see, here the prayer is a twofold, man. First of all, they are challenging annexure 14, page 14. And that is the rejection order.
Because that's, she said, that rejection orders is saying that
It is not granted, that's why it is rejected.
the higher authority and the immediate subordinate authorities of the same department are in the helm of the defense. He said that I have already approved the highest authority or the higher authority for grant of a no use certificate. Now, immediate subordinate authority is empowered to grant a review. One of the conditions, as I understood from for granting a renewal, is that there should be a no use certificate issued by the authority. You are not issued with, and that was a ground for rejection of there. So if it is to be given by you, if you do not give, then how can you reject? You could have kept the application pending. Say that in the meantime you opted. But you can't reject it. What will happen now? Suppose if he goes back after getting a new use certificate, then
Yes, ma'am.
again,
And the second,
and is there any fees or charges levied for renewal, seeking renewal?
Yes, that we have given.
Is there?
Yes,
How much?
75,000.
So she has to pay again the 75,000. Is it the condition precedent for
Yes,
renewal?
yes.
Why? How can you reject? You could have kept it pending, but I can't take a decision because you are not charged. You could have given them a time to bring in. They have to approve the ability to give us on use.
let's see, kindly have a glance to page 40. Last paragraph. Page 40.
Well,
Annexure 14.
yes.
Last but one paragraph.
Page 40.
Page 40.
Yes.
Last but three.
Paragraph 3.
Last but three.
Whereas the licensee has required to fix another date for state hearing, right? Letter number so and so thereafter. Personal hearing was conducted on 21st/6/2025 at 3 p.m. Wherein Sri Rakesh Kumar Dev, authorized person of Lal Trades Agencies, was present, and he has not submitted any further submission towards valid MDCC, which is required under Rule so and so.
No, you are correct. Sir, we are not questioning that you cannot. If this is the condition precedent for a renewal, then you are not wrong. But can you be so harsh when this MDCC is required to be given by your superior authority and who has not rejected their appeal or intimated to them that there is a due? They could have said, that I can't give you MDCC because there is this much of an amount is due and payable by you. So they have to pay.
The mining officer has reported about the higher authority that due is pending, Miller.
Means I'm saying that how can you reject and then 75,000 you did off. Now, suppose if they get the MDCC now, then they can apply afresh. Again, a further amount.
But you may direct the opposite party number two to dispose of that MDCC application.
What about this order? We will give that second application if they make after getting this order, no further charges will be paid by the.
Yes,
Yes, agree.
no, 79,000. They have to pay. That's the certain.
Why they will pay it twice? That's the sole object. Why they will pay it twice?
Take instruction.
What is instruction? Apparent on the face of this. MDCC is granted by director.
Of mines.
Director of this. Who is the immediate, who is the immediate superior authority? No, your superior.
Third paragraph, just speak. Valid MDCC.
All other wanting documents has complied
Yes.
except the valid MDCC.
In respect of applicant company issued by director.
Director of mine.
Ah.
You have written it.
Yes.
That's not that.
Would have said that since they have not given it, it is not in form, we can't proceed on that basis. So, kept in abeyance, you bring that. If you cannot bring, then this player cannot be allowed. Or if there is a rejection order, then obviously you will reject the application.
just express my concern here, is that we have not been able to run. According to the conditions.
Yes, there already a shorter time to decide, but.
No, the conditions of the license does not require clearance of.
We can't direct you to continue.
Yeah, that's- I just had to make the humble request.
Only objection is.
They have raised. I was going through the conditions, for the list.
So that we have said that you have to comply all the conditions except MDCC. So we are directing the director to take a decision on MDCC.
Yes.
That's all. If you go by their own observations, that all the documents you have submitted except this. What's wrong?
No, we thought we'll have,
The conditions why you are trying to make them why.
no, we were just wanting to run meanwhile, that's the only.
That you can't. That you. Yes.
Item number 10.
In the humanitarian. In the purity. What is this? Is it a scheduled area or not a scheduled area?
Scheduled area.
Then have you taken a permission of the ground? Yes. Ready? Put on records. Then you have no case.
You know,
The subgroup provided that in a scheduled area, they can give a query of it, provided they obtain the or the permission.
By a recommendation of the Gram
From the
Panchayat.
Gram Panchayat. They say that they have. Then you have no case.
Let them file the
Let them
application.
file on the 2 weeks.
So they are proceeding with the auction.
Whatever, this is all what has come. The so advanced.
Item and some lordship has been kind enough to bring this into it. But today, your lordship, at 3 p.m., the state level scrutiny committee on this matter has been fixed and the chairman at this is went open not to grant any adjournment at any cost.
Taken up after recess. Let you taken up. Something is there.
Yes.
No, what we say
My lord.
is that though this matter has been decided, but today that hearing. on this
Scrutiny
issue
committee
is
hearing.
fixed at 3, so you wanted to go there and participate.
Yeah, that is all right. But the writ appeal he has filed, possibly it will not be maintainable because another writ was, order was passed.
Yes.
That was challenged in writ appeal.
You wanted an adjournment so that he can participate.
No, my learned brother is saying, let it come at 2 p.m. if your lordship will be kind enough to take it 2 p.m.
If we continue, the hearing continue till 3, then what will happen?
Well, let him participate thereafter.
From day after tomorrow, we'll see.
Yes.
On Friday.
You also may kindly permit me to seek one adjournment in the SLS.
Sir, no, sir, under no circumstances.
My prayer is that my lord may,
No.
no, you also may, my prayer is that it may be taken up at 2 p.m.
To make a mention, your lordship. I mean, pardon to make a mistake. No, your lordship, actually there is a matter in the list. I'm paying for an adjournment, your lordship.
The friend of law.
May I please, my lord. And the only issue involved in this case, my lord, the appeal of the petitioner rejected summarily for non-payment of e-deposit, my lord, late payment of e-deposit. In fact, deposit made 10% while filing the subsequently the notification issued for 12.5%, which was not assessed since the villager and the contractor.
Villager.
Yes, my lord, and his dependent.
SSC.
My lord, the petitioner, my lord, assessed. And it depend on.
There is a SSC.
Contractor.
I think per capita income has.
Village contractor. Village contractor.
It depend on the other person for the GST complaints, my lord. And they also not make the information about the notification. He could not make the deposit.
No, Your Lordship may kindly look into the amnesty scheme, conditional amnesty scheme for condonation of delay in filing a appeal. Your Lordship is well aware about 1071, 1074. So in 2023, a notification CBOC has issued a conditional notification, Your Lordship, for condonation of delay. So there is the specific date has been fixed. Your Lordship may kindly look into that in exercise of the power conferred under section 148, the central government.
The proviso is inserted.
No, Your Lordship.
Who has filed an appeal.
Appeal which has been
before 31st of January 2024.
Your Lordship, 31st January 2024, he has to deposit 12.5% and 10% from credit ledger and minimum 20% of that 12.5% from cash ledger, from cash. So here it is specifically the date has been mentioned. So in my question come to my mind whether this date can be extended. So Your Lordship, here the appeal has been, Your Lordship, appeal was pending and he has not deposited. Under page 15 of the brief, Your Lordship, a notice has been issued. Show me the produce, so far as the production of that evidence of the payment of 12.2.5% that from cash ledger, and he has not produced that, he has not deposited, Your Lordship. And for non-deposit, so now it may not be, Your Lordship, because this, Your Lordship, then Your Lordship, everybody will come and deposit 2.5% and delay will be condoned, Your Lordship. Because this notification.
On 17th
October,
Your Lordship.
prior to notification. Prior to notification, October 17 October 23.
23. So
No. Sir, on 17th and 2024.
No, my lord, 23.
That is the date of order. That is the date of order. Your Lordship, page 15. Page 15 is the date.
Petition was 2nd November 23.
Yes, my lord.
Your Lordship.
Subsequent that
17th October.
While 31st January 2024, his appeal was pending.
Your Lordship. So he has to deposit that 2.5% by that date. By that date, by 31st January 2024.
What was the requirement? What was the requirement on October 2023?
Your Lordship.
10%,
10%.
which they have complied.
Your Lordship.
Now the subsequently a notification case which says.
It is beneficial. It is beneficial for condonation of
That
delay.
is why, sir,
Your
if
Lordship.
it is a beneficial piece of legislation,
Your Lordship.
then the court must also take into account the said aspect in extending it.
Your Lordship.
Is always considered to be a
That's right.
nature, not a mandatory.
And also, Your Lordship, the two, clause 2 and clause 3, may kindly read analogous reading, Your Lordship.
Yeah.
Because those two clauses cannot be read isolated. 2 and 3, both have to read together, Your Lordship. Because he has to comply that condition by that day. Because it is it, by Your Lordship knows very well, Your Lordship, only for limited purpose.
Has come, not available benefit of filing
Appeal,
for by depositing 10%.
Your Lordship.
This notification endorses to their bill.
To that, and whose application has been rejected only on the ground of delay. So for condonation of delay, this, for Your Lordship, the said persons have filed an appeal against the order.
His appeal was not rejected. This appeal was pending.
Your Lordship, the proviso is there. Proviso that an appeal
Is disallowed on which ground?
both Your Lordship
Also, this notification is not a people.
notification or the thing.
Huh?
Your Lordship, basic notification.
Not applicable.
This case,
Your Lordship,
this notification doesn't, right, in this case.
it applies if he has deposited, he could have deposited that money, that 2.5% by January 2024. Then this appeal,
After this notification, right, those persons whose appeals have been rejected.
On the ground of delay.
the proviso, Your Lordship, kindly look in. The proviso
One has to understand.
clause 2.
One has to understand the beneficial piece of legislation. The first paragraph, when you recommend
Mal,
on the recommendation of a council, notifying
mal,
that the taxable persons who could not file an appeal
Your Lordship.
against an order passed by the proper officer on or before 31st day of March
2023.
under section 73 and 74.
Your
Within the time is specified under subsection 1 of sub. So that is the period of limitation. They could not file it within the time. Read with subsection 4 of section 107. The taxable persons and the taxable persons whose appeals against the order was rejected solely on the ground that the said appeal was not filed within the time specified in section 107.
Lordship.
As the class of persons who shall follow the following special procedure.
Lordship.
Procedure for what? For filing appeal
Mal,
in such cases.
mal.
Clause
clause two provides.
said person means two.
Your
Those who could not file an appeal,
Your Lordship.
those whose appeal has been dismissed as time barred,
Mal,
shall file an appeal
mal.
against the said order in accordance with such and such on or before 31st of
Lordship.
January 2024. Then a proviso is
Your
added,
Lordship.
provided
Your Lordship.
that an appeal against the said order filed in accordance with provision of such and such
Yeah.
and pending before the appellate authority before issuance of this notification
Your Lordship.
shall be deemed to have been filed in accordance with this notification
Yeah.
if it fulfills the conditions specified in paragraph 3 below.
Your Lordship.
No appeal shall be filed under this notification unless the appellate has paid
Your Lordship.
either in full
Your Lordship.
or such and such or in sum equivalent to 12.5%
Yeah.
of the remaining amount of a tax
Fine.
in dispute arising from the said order,
Your Lordship.
subject to the maximum of 25 crores, in relation to which the appeal has been filed, out of which at least 20% should have been
Fine.
paid by deducting from the electronic.
My,
No refund shall be granted on account of.
Your Lordship, not necessary. Not necessary.
So what was?
I respectful submission, Your Lordship. So this is deemed pending as per the proviso.
Correct.
Your Lordship.
True, that's true, but certain.
Your Lordship, but condition.
Notified. The authorities have a, but this is authorized to inform that this is what is there, you have to pay.
Then what is your problem? You have not complied. This notification provides.
It was not in his knowledge and the intimation as in the appeal are not communicated. Yes, ma'am. Not intimated.
Notification.
You know better notifications when his appeal was already pending and within the time.
Your Lordship.
It was within time.
Yes, ma'am. None. Within as per notification. As per, right, Your Lordship.
Not notification. Prior to notification.
No. That was in delay.
But that was delay half days.
201 days. Your Lordship.
So you should have notified him that I will extend the period of limitation. If you deposit, suppose if they know, they don't, then the authority has to decide the application for condonation in its ordinary perspective. Decide. Don't, he will not avail this benefit. He will not avail. You decide the condonation application.
Constraint to reject.
This is not used, but put both the sides of the coins against him. At least leave one coin in his favor. One side.
Let's see.
The
appellate
notification is the beneficial piece.
The appellate authority should not have
Somebody who could not file, extended period is given up to this January 2024.
20.
Correct? If you want to avail the extended period, then you have to comply this. If person says, I do not want to avail extended,
Your Lordship.
but my appeal is pending.
Is
You decide in accordance with law.
Your Lordship.
Is the person journal suits? Photo number 5.
Your Lordship, a limited way, Your Lordship, a question comes to my mind. Whether Your Lordship is absolutely right, so far as the appellate authority should not have condoned the delay on the ground of that, he could have rejected.
No, that you decide.
Your Lordship,
There is no ground
my
for condonation.
my respectful submission before Your Lordship is that 31st January 2024, as per the proviso, Your Lordship, proviso of clause 2,
Extension of a time.
can it be extended again, Your Lordship?
No, please.
Well, Your
There
Lordship,
is a-
this question comes to my
There
mind.
is a gulf of difference between an extension of time to file an appeal and a power to condone the appeal, the delay.
Your Lordship.
Two are distinct facets. If you want the opportunity of an extension of time, then there cannot be any delay. Then it is within the time.
Your Lordship.
You can't say it's a delayed appeal or belated appeal. No. It is.
You will not
within the
comply,
time.
you will not
Within the
comply.
time. But if you put the conditions that yes, if you want to avail the period of extension, then you'll have to comply these. Suppose if he does not comply and he stick that I want the older one,
Your Lordship.
you decide the application for condonation on merit. You have a power to condone. You may refuse to condone. Take a decision
It may not.
whether to condone or not to condone.
It may not be possible to issue notice to individual dealers, Your Lordship.
So they have filed an appeal, sir.
Notification has been
They have
issued.
filed
Your
an
Lordship,
appeal.
in person.
They have filed an appeal. This is the second opportunity option is given by extending the period of limitation on conditions.
Your Lordship.
That's all. It's an extension of the period of limitation on conditions. If they comply
And after
this,
that-
then this condonation part will go.
After that, on 19th March, we have issued notice to produce. Your Lordship, let me take.
I have my own view.
Your Lordship.
No.
I know it is beneficial, but whether that date can be extended, if
No,
that date not
please,
comply.
kindly visualize the situations. The extended period is brindled with certain conditions.
Your Lordship.
It does not rule out or wipe out the original period of limitation.
No,
It's stuck.
Your Lordship.
If suppose somebody did not avail of, then his appeal would be treated to have been filed belatedly under section 107, subsection 1. And the authority can condone under subsection 4. That power is there. Let him decide. Say, I do not find any ground for condoning the delay. That's within the authority. Second issue is that if this notification came during the pendency of the appeal, which is already there, then at least it is an authority who has to communicate that this is what if you want. Oh. Item 3. So you were given an option.
But that is only not served on the asset and it is not available to internally.
Your lordship, if everything will be said that it is not our, then your lordship ignorance of
Others
law.
who are a villager.
Yes, well, is it depending on others for the compliance of the GST return filing and accounting of the, and they are not communicated him, either they have not gone through that portal or.
That is solved by this.
Your
19/3/2024 as it emanates from the order itself. That intimation was issued to the appellant on 19/3/2024, produced proof of payment. So whether this intimation was served.
Your lordship, that has been uploaded. Your lordship,
Yes.
I'll take.
Whether it is properly served or not, you take instruction.
I'll take.
What is the harm?
Your lordship.
The appeal was filed by him in person.
No, man, by other person, through other person.
To other person means
No, I
the
don't-
legal
Tax
expert,
tax
legal expert,
tax consultant.
legal expert, or a domain expert. Let me
Handling
rephrase.
GST matter.
May not be legal. Let us see the domain expert. Domain expert does not know that what are the notifications coming up.
I think they have not communicated him and that's not the problem. That notification and the 2.5% extra is necessary.
Because something more which is expected from him was not given to him. That's why he did not.
Several they are facing all this, even the assessment of past expertise. As to PSI
Whatever
expert,
ex party, if you remain an ex party, what can be done?
they are not taking care. That is the problem. The small assessors are facing this type of the uploading of notice and order, not aware of website.
Who maintains your records? Or transactions? You are a villager. You must maintain the register. You must maintain an account. You are a GST. You are a GST.
No, my lord, during that period, that is the refund of the security amount. They are imposed the GST on a security amount, refund of security amount.
39,000 is the tax.
Only, my lord, the small amount, they are imposed 3 lakhs some odd refunded the department, the government department.
Is the only.
Tax 39,000, penalty and the interest मिला के 88,688. And even in between another scheme has come that once you will deposit the tax, interest penalty will be. That scheme also he has not availed.
Amnesty scheme.
Amnesty scheme he has not availed. So without availing anything, all the allegation against him.
Very difficult.
Item number 12.
Kindly have a glance at order number 2 dated 1/7/2025. Can I read it?
No notice was given to you.
Yes. At the time of rectification.
So, notice given.
Your Lordship, Your Lordship, I have obtained the instruction to hold Your Lordship, facing Your Lordship, to support the issuance of notice, Your Lordship. Admittedly, Your Lordship, focus notice, notice of hearing has not been granted for hearing. This is a mail receipt, Your Lordship. And so far as the second part is concerned, page 57 of the brief, Your Lordship, so far as the disposal of the rectification application 161, Your Lordship may kindly look into that. This 161 application has been dismissed, rejected solely on the ground of limitation, Your Lordship. It has to be filed within a period of 3 months. And on the last occasion, Your Lordship has pointed out that the assessing officer has gone into the merit of the case. Your Lordship may kindly turn to page 57 of the brief.
Minutes at page number
And my
56.
instruction,
Minutes at page number 56 of the brief.
page 57, the 161 rejection order, Your Lordship. The second para, Your Lordship, you have applied for rectification. Your Lordship got it. You have applied for rectification for the above order by the ARN number so and so and dated 13th March. The taxpayer has asked for rectification and applied for rectification on a stay which is beyond 3 months from the date of the demand. With reference to the application referred above regarding rectification of order, the said application has not been found satisfactory. Accordingly, the applicant. So, for the meaning of what my instruction, Your Lordship, for the assessing officers, Your Lordship, I have submitted the last paragraph and also Paro's comment on the second page, Your Lordship. Only it has been rejected on the ground of delay, Your Lordship. And since it has been rejected on the ground of delay, for that.
No, minutes. Kindly have a glance at page number 56. At page number 56.
Whether the power to extend or condone is there for rectification.
Your Lordship, only the that says 161 is a conditional that he has to file the application within a period of 3 months, and that has to be disposed of within a period of 6 months.
Is there any provision
No.
relating to extension of time or for
No, no.
the rectification?
No.
In absence
No,
in absence of
Your
any
Lordship.
provision for condonation of delay
Your Lordship.
in the special statute,
Your Lordship.
whether section 5 applies,
Mine.
that is decided by this province
Your Lordship.
in 2015.
Mine.
Specific question has been answered
Your Lordship.
in favor of the parties.
Here, Your Lordship, I
So,
here there is a condition. So.
province
Again,
of Akshay Kumar Parla.
again.
Where is it? He prefer home. See, upon the phone.
Here, Your Lordship, section 5, here, Your Lordship, section 5 may not be applicable. Here, section, here that section 5 may not be applicable. Why, Your Lordship? Why, Your
Attorney
Lordship?
Senior is submitting at page number 57, that is the annexure to the rectification order. But the actual order is at page number 56, my lords. If your lordship will see page number 56, with reference to the application referred to the above regarding rectification order, the said application has not been found satisfactory for the reason attached here. Accordingly, the application is rejected. This clearly states, my lord, My application was unsatisfactory on that ground, on the basis of merit they have rejected. So what I am submitting,
The reason attached.
reason attachment, they, then why did they give the,
Please. We are reading that sentence, please explain.
limitation is one of the ground, my lord.
So,
But they have gone on merits, that is
so
what.
There is no reflection on merit, only one sentence. And this has to be read conjointly with the annexures.
Grateful.
There is only a rejection on the ground of limit.
On one part, my lords, they are,
Nothing has been spelled out.
but,
Nowhere.
but if we'll see,
They have not touched upon the fact.
indeed, my lords, but if we'll see 161.3, my lords, as per last occasion, my lords, at least as per principle of natural justice, my lords, 161 clearly states that one opportunity, one notice is to be given. Had they given me a single opportunity to state that why the delay was there or whatever the reason was there.
To extent the time is provided.
No, but
the notice is,
at least when I am
the notice is.
6 time period is there, 6 plus 3 months. If we'll see it on that aspect, 9 months, it is within the period of limitation.
so
Where is the period? Show us the period of limitation. Show us
any
from the
order,
provision.
any order, any decision,
Delhi High Court decision is there, my lords.
any order or a decision.
Show us.
Delhi High Court decision is there, my lords. I had given in last occasion, my lords.
Show us the provision.
My lords, I have one decision regarding 161.3.
Madam, it shows the decision from the act that it 161 says that beyond 3 months, it can be. Show us.
161 minutes.
Yes, please. Which one? First.
Without prejudice to the provision of section 160 and notwithstanding anything contained in any other provision of the act, any authority who has passed or issued any decision or order or not notice or certificate or any in such decision or order or notice or certificate or any other document either on its own motion or where such error is brought to the notice by any officer appointed under this act or an officer appointed under the State Goods and Services Act or an officer appointed under the Union Territory Service Tax Act or by the affected person within a period of 3 months from the date of issue of such decision or order or notice or certificate or any other document as the case may be. This is the 3 months, my lords. Then after that, in the proviso, my lords, there is a period of 6 months which says that provided that no such rectification shall be done after a period of 6 months from the date of issue of such decision or order or notice or certificate or any other document. Further provided, the said period of 6 months shall not apply in such cases where the rectification is purely in nature of correction or clerical or arithmetical error arising from any accidental slip or omission. So, Millers,
Last proviso.
last proviso is provided also that where such rectification adversely affect any person, the principle of natural justice shall be followed by the authority carrying out such rectification. My humble prayer before your lordship is that, my lords, this issue is decided by Honorable Delhi High Court, and on the last occasion, my lords, I had given that judgment of Delhi High Court.
Section 5 of the limitation act may not apply, you will see, because 3 months, 3 months. He has to file with the.
This is not a case where there is an express provision of section 5.
Yeah.
It is a case where the special statute also contains
Your Lordship.
a provision relating to a extension of time or a recognition. Then the authority has cannot written down that provision.
the first provision, the provision as well as the proviso, if both are read together, the first proviso, he has to file within 3 months from the date of order, and the officer has to dispose of within another 3 months, because 6 months will be counted from the date of order. So 3 months, 3 months, when this is a time bound, so section 5, if section 5 will be allowed to him, then what is to officer?
The second proviso.
The clerically,
Means dilutes the concept of a limitation.
your lordship.
It dilutes, it says that if it is a ministerial or a clerical error, then
6 months.
even these 3 months, 6 months will not apply.
It's only 6 months will not apply. 3 months of
The 3 months and the 6 months.
provided for the said period 6 months shall not apply in such cases where rectification is clearly nature of correction or clerical. That 6 months, beyond 6 months, assessing officer cannot touch, cannot pass any order. That's your lordship. What I understand.
No.
Your lordship, what I'm sorry.
There are multiple sources for invocation of section 161, subsection 1.
Your lordship.
Multiple sources.
Your lordship.
A person, affected person can
You can
also
find.
go for that a limitation period is there.
Right.
The power, source of power is also provided there.
Your
for
lordship.
authority to do it.
Your lordship.
So there are multiple sources which can be done. What it says is that there is a limitation for them to file within 3 months. There is an obligation that we have to do it within 6 months. You know, take the order that you.
Yes.
But second proviso says that when there is a ministerial or clerical error,
Your
then the question of this 6 months will not arise.
lordship.
That means that the entire application or rectification should have to be made within 6 months. It will not apply in case of a ministerial error or a clerical error or this. Because as and when it is brought to the notice of the authority, he can suo motu rectify this. Suppose a figure, everything has been stated in the bottom, the body of the order.
Your lordship.
But in the ultimate paragraph where the demand is raised, say one more zero comes, which makes it a demand of 10 times more, which makes the demand 10 times more.
Your lordship.
Whereas he has decided 10 times less.
Right.
If it is brought to his notice, he can rectify at any point of time.
Your lordship.
6 months will not go.
Your lordship.
Because he will say, yes, this is a typographical error.
Your lordship.
1 0 is put
Your lordship.
after that. I think what the spirit of the act.
Your lordship. Right. So what is
You
the,
can't say that beyond 6 months cannot. It can.
if this condition?
It should be whether it was an arithmetical,
Let me
ministerial,
friends.
or a clerical.
Let my learned friend satisfy your
Question,
lordship.
let's put inside.
Let my learned friend
My-
satisfy your
Put
lordship.
inside.
My humble submission before your lordship is, on the last occasion, your lordship put a very
What?
appropriate question to my learned senior, that as per 161(3), before deciding a case,
Go by the observation of a judge unless.
No, Millards, no, Millards.
It will order and sign.
I bow down to that, Millards. I bow down to that.
Only the pursuit of understanding.
What,
really.
yes, Millards, what I'm,
Don't take advantage of that, will you ask this question, particular.
no, Millards, what I'm humbly submitting is that whether this matter, this rectification application will fall into the subcategory provided in the proviso 2 or proviso 3. For that, at least a notice was supposed to be issued to me to show that this is the arithmetical error or this is the clerical error for which you can entertain this rectification application. For which, Millards, the Honorable Delhi High Court has clearly stated, placing reliance to a Madras High Court judgment, Millards, that the grievance of the petitioner is that while deciding the rectification application, the petitioner ought to have been afforded a hearing in terms of proviso 3 of section 161 of the GST Act. The relevant provision is so and so. It is submitted by the learned counsel that no hearing was given in the rectification application and the same was rejected. This, according to the petitioner, is a contrary to the provision laid down in the Act. Reliance is also placed on the decision of Madras High Court in WPC number 7338 of 2024, decided on 21st November 2025. Then, Millards,
Single bench decision.
this is a division bench decision.
may have a persuasive value, but
This-
my reading may be different.
Millet, the statute is very clear, Millet.
Very
Before
clear.
deciding is,
Then let us read the word sentence in extenso.
yes, Millet.
Please start that provides.
Yes, Millet.
Let us understand the English language, what it says. Please read, provided
Also,
that where such rectification adversely affects
any person.
means what? If there is rectification done and it adversely affects the person, the principle of natural justice shall be followed by the authority carrying out such rectification.
Yes.
Suppose if he refuses to rectify, not you,
In my case, Millet,
whether the principle of natural justice will apply.
yes, Millet. Because the reason being,
There is no rectification done.
even if there is no rectification done, Millet, the Act says that where such rectification, any rectification, you are passing any order which adversely affects.
Oh, it says if it is rectified, then if it affects. Suppose there it can be, you have to correlate. That means that if they want to do a suo motu rectification under subsection 1,
No, Millet.
if they want, and then they rectified the order, which adversely affect you, then it says that you can't do it unless you hear me.
Now down to that, Millet, but the statute clearly states that when any order
I
is
do not know
passed,
clear. It's, I think it's such a dark cloud.
if
I do not
this-
see,
this
even
order-
not even a silver line behind the dark
yes,
cloud.
Millet, the what adversely affects means any order,
Such
Means if the
Any
rectified, then also-
rectification
then also.
such means what?
such rectification means
Previously discussed.
any rectification application is being decided, Millet.
Oh, madam, no. That's
Which
not English
administrative
language.
Miller.
That's not an English language.
Yes, Millet, that is.
Sorry.
That is already.
Then how adverse this rectification adversely affect you? It does not.
Yes,
You may not seek for a rectification. Let us see the example. You are happy with the original order. You do not want rectification. But the authority of his own rectified it, affecting your rights.
But
Then,
no, in that
You are
case,
already
Millet,
affected.
if
Already
the authority,
yeah, I was bum. I do not want to make them wise. I was just listening you how far you can go.
On the last occasion, I have argued, dear, let's see,
No argument.
adversely.
No argument. Then what to do?
Millet,
Limitation.
no, Millet, limitation is not there. Let them consider by giving one opportunity. But at the time of rectification, Millet, just one opportunity.
Yeah. Yes. Do not decide, otherwise my view will.
Page
go for
36
the- or-
is the application.
Go for it.
Let's go take one single opportunity may be granted for.
No, sir. Then
Before-
I have to write and my conscience and reading is different. My conscience and reading. Then I will say that how to harmonize the different subsections and the provisions. That will foreclose your door for an appeal also.
Then let's make submit one thing.
No,
No.
only remedy now is 107.
Let's make submit one thing.
Still you want
160.
to argue?
One.
After one argue,
No, let's only one thing I will submit. The order is passed beyond the period of limitation as per section 168A. So let it be
And as
pending according to.
tendency of reproduction, you can take.
No, Millets. What I'm submitting is let it be tagged along with those 168 and writ petitions. It will be heard on that ground.
161 also.
168A. Limitation ground also I have taken, Millets.
No.
If you argue, then you are inviting this us to interpret first proviso, also,
Even if,
which will be tuned with the third proviso. It's better to go. Choice is yours. If you invite us, I'm subject to my brother agreeing with me, I will declare. I will declare this.
You have filed this restriction on 10/4/2024, well within the time. We are protected. And it
Yes,
was
but-
pending, this restriction was pending. So. The order under challenge was 13/3/2024.
no, Millets. I may be permitted to withdraw this petition, Millets, to file a
No,
appropriate application.
what is the defect?
The defect, nothing is there, but there is another ground.
That's the power the court enjoins.
Authority is still not.
I'll find out the numbers.
Says where the court is satisfied that the suit must fail by reason of some formal defect, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit or a part of it, then it may on such term as it thinks fit grant the plaintiff permission to withdraw from such suit or such part of the claim with liberty to institute a fresh suit in respect of a subject matter.
I will file appeal in that case, Millets.
So you have not pointed out that what is a formal defect or a fatal defect which is incurable.
I will file
Then
appeal.
why will permit you to withdraw?
I will file appeal.
Sometimes we just close eyes, but it does not mean that in all cases, you know. Why did the order of rectification that is
Item number 13.
Please here level to petitioner challenges the first appeal order under GS Act. Both you. Both. Yes, ma'am.
Yes, well,
Item 14.
installation,
Yes.
both the matters.
Both the machines.
Item 15.
Now. Last occasion, I submitted the show cause notice for carrying out the assessment as well as the personal hearing notices were not served on the petitioner lordship.
At what stage?
At the show cause notice stage lordship. Show cause notice was not served. Hearing notices calling for the personal hearing was also not served lordship.
Not sir.
Not served lordship. It is ex parte order lordship.
Yes, on last occasion, you lordship was direct to an instruction. Instruction, I have received the instruction, but the service of the notice is not available with the department. Because the-
Therefore, if you can't produce the document that it has been served, then in that event, it will presume that it was not served.
Department has sent by registered post that document.
But there must be a postal receipt.
Postal receipt.
There must be a tracking report of the India Post official portal.
Tracking report is not available.
So then what can be done? We are sending a notice does not tell about to service of the. It may return with certain remarks. It is not.
That has not been returned also by it.
Lordship may publish the.
We have sort of the inspection of the.
You would have asked for a certificate from the postmaster. There is a provision, you can make an application to the postmaster, give a certificate whether it has been served or not.
Was posted a week before also within such a short span of time, it cannot be obtained and be posted on.
Nowadays, previously it was a longer time they used to consume. Nowadays, they know, they can open the portal.
That exercise has not been done.
Actually, may publish the.
Now you have a notice, you have a show cause notice,
Yes, lordship. Now also they served only order lordship.
they have not given you a show cause.
Yes, lordship.
So copy of the show cause has to be given to them, give them a time to reply and decide afresh. We are saving your limitation.
Simply furnish lordship, similar decision lordship has taken.
Very fast, but we will direct from the stage of the show cause. They will give you, do you have extra copies?
My humble submission, let them appear before the authority on a particular date as your
Without knowing that what they have to give an answer in a show cause notice, at least you will intimate them that what they have to give an answer. They can't go before the authority with surprise.
That's previous
I have the
communication.
copy of the show cause notice with you.
Presently, I don't have my.
Give it to straight away.
That's
We are saving everything and you are.
I will serve the show cause notice within 3 days, my lord, sir. It will take 3 days to serve.
The
May make such observation.
And
My lords, may yes. My lords, may make such observation in the order. My lord. Because presently I don't have that.
Rewriting the money so that the revenues interest is not.
I'm obliged, ma'am.
on electronic mode also.
I don't know.
Otherwise, they will say, I did not notice, there was some technical glitch.
Is from. Here.
Yes, I will comply the directions, ma'am.
Yes.
Yes. Obliged.
Deeply obliged.
Item 16.
Looking to now, because this is what we have done. Yes, please.
Your solution?
Like 10%. Cannot possible.
Tribunal.
17.
This matter relates to cancellation of exception.
Item number 18.
My lordship, the state have filed this appeal challenging the order of the single judge bench.
Judgment. That page 13. Annexure 1. Basically, a case of no work, no pay. The period from 93 till 2010, admittedly, the petitioner has not worked for different reasons. The institutions where he was posted because of certain agitation and resentment by the employees as well as the community. The petitioner was not allowed to join. Then later, in 2010, he was adjusted against a post of assistant teacher in a Urdu school. The period for which from 93 till 2010, for which he has not worked or discharged his duty, he was not allowed any pay. So that is why he approached this honorable court in a writ petition. And the honorable court, right, the annexure 1 allowed the writ petition on the ground that the principle of no work, no pay cannot be attributed to the petitioner. Admittedly, when the petitioner was ready and willing to join, but because of the slack and latches on the part of the state authorities to ensure his joining, the principle of no work, no pay will not apply. That is the fact is, physically he has never worked for that period from 93 to 2010. And if I may refer to the Rule 56 of the Orissa Service Code. So Lordship will find. Subject to, may I place it to Rule 56 of the Orissa Service Code. Subject to the exceptions specifically provided in this rule, a government servant shall begin to draw the pay and allowances to his post with effect from the date on which he assumes the duties of that post, and shall cease to draw them as soon as he ceases to discharge those duties. So here, my lords, from 93 till 2010, he has never discharged any duty. He has never assumed any charge. The reasons may be not attributable to the
What is this?
respondent.
This is the Orissa Service Code.
My lord,
Then what is this notification beneath it?
this is of 78, my lord.
What is?
The rightful claims and admission of the area of financial benefit to government servant. Wrongly deprived of his rightful claim to the post, and his claim is subsequently allowed either after judicial decision or otherwise. He is appointed to that post with prospective effect. In such cases, judicial verdict in that government servant whose rightful claim is subsequently allowed by the government shall be entitled to pay and allowances.
What does this mean? I do not know. Subject to the exceptions are specifically provided. I do not know what are the exceptions.
That exceptions, so.
What are the exceptions?
Exceptions are against. But executive instruction certainly cannot override the statutory provisions. But fairly, I would say, looking into the facts of the case, that those exceptions, in fact, I tried to is subject to my lord, subject to the exceptions specifically provided in these rules, it is said. So the executive instruction certainly cannot be considered to provide the exceptions substituting the rules.
It's not a rule, it's a clarificatory in nature. that
It is a
can be done
clarific-
Through an executive.
Instruction.
No problem.
So they have accepted the course verdict.
Yes.
They refused it. They have adopted. So whether still you will persist this repeal.
Well, at all. Even looking into the facts of the case, I would fairly say.
We were actually deprived.
Yes.
We were
Yes.
all along ready to discharge. You did not allow me.
From your gesture, it seems you.
Yes.
I have read the entire fact.
Yes.
I see the proceedings.
This. Hmm.
Yes.
For the orders on Monday.
Item number 20.
There is 6 days delay. But here may submit the impugned judgment is arising out of a common judgment arising out of 2 writ petitions, and the judgment is challenged in another appeal, and the division bench has reversed the judgment of this.
Why you are proceeding?
Right?
My lord, the
Yes,
writ of
but
has been
against
challenged
that, my
before
lord,
the Honorable Supreme
against
Court, my
that,
lord.
yes,
And the Supreme Court has issued notice.
Yes, my lord,
Yes.
Mostly in 4 posts has been
yes.
vacant, my lord. 4 posts has been vacant, my lord, required the Honorable Supreme Court. In the present case, my lord, 3 petitioners are there. In the earlier case, 4 petitioners.
This is the
So this is the case, so the don't delay, as on the basis whereof we can also keep.
Yes.
Post
yes,
What more?
and this is the judgment of the.
It's not a petition for resolution in beginning of.
Two writ appeals have been filed, my lord. One is document
Oh,
90.
please, Order was passed.
But annexure 3.
That was 10519 of 24.
Lordship may find annexure 3 at page 89. Running page 89. So the writ petition has been disposed.
Until appealing for the respondents, they approach the matter for appeal.
Yes.
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 Item 22.
Malad, I appear for the appellants in this matter. Malad, the order which has been appealed, Malad, is dated 6/1/25, Malad.
Yes.
Okay.
Item 23.
This appeal, I may be permitted to withdraw the IA for limitation and file a pressure application now, because there is some defects.
Hello, the delay may be condoned in this matter because this matter is similar to item 18, my lord.
No,
It is not
your
one
rescue.
lord.
This is not similar to 18. 18 is a different case. This
My
is
lord,
a-
they are relying on the rule 56 of the Odisha Service Code, my lord.
No,
Yes, yes. I'll have
23, this is a different matter, my lord, altogether.
Now you see, you want to do. If we find it is not similar, then your consent will be standing again.
Actually, let them find them.
Four.
Before on the last opinion, your lordship. Your lordship, I see order dated 14/5/2025. 14 May 2025 order. Your lordship directed me to disclose the progress of the disciplinary proceeding initiated against the aforementioned 20 persons on the said date of listing. My lord, development I am.
Right on the. I'm referring to his affidavit only. I'm assisting your lordship in this matter. We have filed that affidavit on 12/5/2025, and your lordship had directed me to assist your lordship with regard to what the facts contained in that affidavit. I have brought it by way of a brief synopsis, as I usually do. On this occasion, I filed affidavit. Synopsis number 3 is there on your lordship's board, and the top flag marked as flag X. Lordship has it.
Yes.
In fact, if your lordship sees point number 2, the affidavit which they have filed, in fact, relates to
This flag X.
flag X. At the top, I think it shows, it indicates in the cause list that it's at the top.
It's synopsis 3.
Yes, synopsis 3. Because every time they file an affidavit, I just try and call out the facts of their, the contents of the affidavit. The lordship sees this, point number 2. I tried to clarify the lordship that, in fact, they had initially filed a additional affidavit. Koraput, Puri, Ganjam, and Raigad. Out of the 28 number of detected fake certificates case enlisted under TB2, in 6 cases, teacher have been dismissed from service and 1 has resigned. Case of 1, HON'BLE has been found to be genuine. However, in the rest 20 cases pertaining to Koraput, Ganjam, and Raigad, investigation is still on. My third point is that since this Honorable Court by order dated 6/5 had called for action taken report from the districts of Bargarh, Kenjur, and Kendrapada, the status report has been filed under Annex E/2 to additional affidavit dated so and so, indicating the status of investigation and action taken against elementary teachers in 3 districts. That is as on 30/4/2025. I'll just detail it on table. If lordship comes to page 3 and the summation at the bottom, I'll just read out. In summation A, Annex E/2 is the action revealed that 14 teachers' fake certificates have been dismissed from service. The rest 6 teacher interim orders are passed by the court in restrictions which are in operation. So whatever they brought in record, the next page I've just detailed what the suggestions are for your lordships. At page 4. May I please, Madam?
Latest update of 30 cases.
Investigation is underway.
And as indicated, I'm answer to so and so, an investigation was initiated way back in 19/7/2023, as has been indicated under answer so and so, previous additional affidavit dated so and so. Direct elementary education by letter so and so filed to the CBI2 has called upon all district education officers of state Orissa to submit updated ATI. Whether any updated ATI has been received from the districts. And the third point is further the Director Elementary Education of Bhubaneswar may advise this honorable court with whether it has received any updates ATR from the DO Ganjam in pursuant to the letter which they have annexed as annexed. That is my.
In terms of your lordship's last order, dated 14/5/2025. I wrote to the authority and I received the instructions about those 20 teachers. The chart is the instruction I have given you. I have served a copy to my learned friend also. Your lordship will find as many as 11 such teachers have been dismissed. One has expired. In 2 cases, proposed penalty has been served on them, and in 6 cases, DPs are in process. 11 have already been dismissed, 1 has expired. Your lordship will find from the chart.
How many in the process?
In the process, 6 BP is in process. Your lordship will find process, first one is process. Thereafter, my lord, your lordship will find 14th, 14th, 15th, and 16th, 17th. And last one, 20. These 6 cases are under process. 11 have been dismissed, 1 is expired, and in 2 cases, proposed penalty.
No, one has resigned.
1 expired.
One is.
One.
The next page. Total 20.
Yes, my lord.
Please look at it. You have not shown.
Total 20, dismissed 10, terminated 1. Resigned 1, expired 1. Resigned 1.
I think it's a bit of verification at under this point.
There is a discrepancy.
There's some discrepancy.
No, actually, as a matter of fact, if we take the total, it becomes 21. That is, there is a mistake. This 10 plus 1 plus 1 plus 1 plus 5 and 2.
It will be 20.
20.
10 plus 3 plus 5 is 18 and then 2.
Sorry.
20.
You can have it verified and bring it by way of an affidavit on record.
Yes, I received the instruction today morning. I'll give it in affidavit after taking stock from the department about this mistake.
This is something what we wanted is that there are many things we should come.
Those things have already been clarified, my lord, about the allegation that midday meal has been given to misnomers. Such persons are not able. That is not a correct. That is not correct.
No, that one, no. These kind of suggestions have come regarding this 20. It seems that this investigation was initiated way back in 1907. There is a delay. The secondly, what steps you have taken at one stage it is there.
About this 20 persons, I took instruction.
DO Ganya, you know what he has done.
If your lordship remembers, on the last occasion, I filed that affidavit there. We have stated that even after dismissal, criminal prosecution have been initiated against certain officers. Here in this report which I received about that criminal prosecution, nothing has been reflected. Your lordship may call it 1 week after. In the meantime, I'll take instruction even after dismissal. In some cases, criminal prosecution have been initiated earlier. In these, in case of these teachers, I do not know. I'll give it.
My lordship is endeavor to help them correlate with the previous affidavits.
Yes,
They have been filing quite a number of affidavits. So what I do in this brief synopsis is try and cull out those factual aspects.
So now we are concerned with 20%.
Yes, yes.
So this by an order dated 14/5/2025.
25.
If you want.
May please understand. Lordship, on to file the agenda, the counter appeal filed by the state matter.
It is the first extension or no?
It is the second time extension.
Because
There are some instructions to be sorted.
my view is that if it is a second extension, then we have to pay. First extension automatically.
Only under 10 days, madam.
Maybe, even 1 day. Yeah.
You need some instruction, madam, that's right. Last.
I can't.
In the last judgment, we need.
There are other members of the bar has suffered. So I can't treat you differently.
There are some points.
Whatever. Either we proceed on the basis thereof, then you have to extension.
Your lordship may call it tomorrow matter.
What?
May the matter call tomorrow. We will try to file.
You want to argue tomorrow? Come tomorrow.
As your lordship. As your lordship.
24, tomorrow.
Right. Item 26.
May I please do? This petition. I usually prayed for issuance of a writ to direct the state government that having been selected, being the successful tenderer, the work order be issued in my favor. But during subsistence of the writ, they cancelled the tender, so I've amended the writ petition. Now
Cancellation. How far the court will interfere?
Yes, Maharaj, I'll show that to your lordship. May I just take your lordships to the facts of the case before I come to the law matters? Your lordship may initially see page 67, the brief. Even in cancellation, there has been a recent judgment of the Supreme Court where the Supreme Court has interfered in what case cancellation can be set. Yes, my lord, and this goes beyond exception. My lord, I'll show to your demonstrate it to your lordship from the record how I have been victimized. I was initially blacklisted. I fought this before this honorable court. I succeeded. Despite my success, they did not honor the honorable court's order. Even in the affidavit filed subsequently, they say that I continue to be a blacklisted contractor, despite the fact that it has been quashed by this honorable court just because a SLP was pending and no stay was granted. Ultimately, the SLP has also been dismissed. Your lordship may kindly take page 67 of the brief, my lords. Page 67, your lordships will find that I emerged as the successful tenderer. Serial number 2, my lords. There's the petitioner. Next, your lordship may see how they deal with my application, my emerging as the successful bidder. They, in their counter affidavit filed on 21/8/2024, they have enclosed the proceedings of the tender committee. 21/8/2024. The counter affidavit by opposite parties 1 and 2.
Yes.
That the proceedings begin at page 11. Your lordships may come to page 27.
Internal.
Yes, Maharaj. Of that, yes, internal page 27 of that affidavit. Serial number 7 is tender concerning me, Maharaj. Serial number 7 at page 27. That concerns the present tender, Maharaj.
Yes.
Now, your lordship may take a turn to page 29. Now, after the table, in the table, it's been indicated that I am the first lowest at the top, serial number 1.
quoted percentage rate is 14.99.
Yes, Malad. Less. Now, just below the table, the sentence, Malad, the chief engineer, DPI and roads, Odisha, intimated that the L1 bidder has satisfied the qualifying criteria for bid capacity. The tender is valid till so and so. Thereafter, earlier the tender was placed before the meeting of the tender committee of the Works Department and the chairmanship of the Principal Secretary Works Department for discussion. After detailed discussion, the committee unanimously decided to place the instant tender in the next meeting of the tender committee for further discussion. Now, over the page, Manoj. So the paragraph beginning there, Manoj. In the meantime, the CDPI Roads has submitted his report to the Works Department, while letter number so and so stated that the SLP has been filed by the state bearing diary number so and so, challenging the judgment dated so and so of the High Court of Orissa in WPC number so and so. The said SLP is sub judice before the Honorable Supreme Court of India. Again, the tender was placed before the meeting of the tender committee of the Works Department under the chairmanship of the Principal Secretary Works Department, held on 14/3/24.
Decided to wait for further development.
Further development. And that further development, your lordships will find in the additional affidavit dated 2/12/24.
Okay.
2/12/24, they filed another additional affidavit
On behalf of?
on behalf of opposite parties 1 and 2. Additional affidavit filed on behalf of opposite parties 1 and 2.
Yeah.
Now, your lordships may take page 19. Your lordships may come page 21. The sentence begins, paragraph beginning, earlier the tender was placed before the meeting of the tender committee of Works Department and chairmanship of Principal Secretary Works Department in the meeting held on 2/9/24 at 11 a.m. for discussion. The tender committee observed that the recommended L1 bidder RAPS Infratech was earlier blacklisted by the chief engineer Bridges with approval of the government in Works Department. Though the said order of blacklisting of so and so was quashed by the Honorable High Court of Orissa in judgment dated so and so, the department has challenged the said judgment dated of the Honorable High Court of Orissa in WPC.
So the matter was pending before
the Supreme Court. After hearing the matter, the order dated 13/5/24 have granted 4 weeks time.
That's I have already read.
Yes, Madam.
So
Now,
the matter remained pending there.
Remain pending.
Yes.
Now, next page, your lordship, page 22. Last, just 4 lines of that page.
Yes.
The paragraph beginning the instant tender, your lordship may come to the last 4 lines. Keeping in view the fact
Was blacklisted challenge before the Supreme Court. Keeping in view of that, is blacklisted contractor.
it will be appropriate to cancel the tender and go for fresh bid. That was the decision taken. Now, pursuant to that, my lords,
No, so they cancelled it already.
At-
Decided to cancel the tender.
yes, my lords.
Go for an invitation of fresh bid.
Sorry, my lords.
And to go for
Yes, my lords.
invitation of a fresh bid after obtaining the government approval.
Approval. Now, my lords, thereafter they cancelled it, and your lordship sees I have filed an affidavit on 26/4/2025.
Yes.
Now, herein at page 3, your lordships will find the order of the Supreme Court that the SLP filed by the state was dismissed.
Yes.
Now, my lords, my point is very short, my lords. My submission to your lordships is that even though I had succeeded before this honorable court in the first writ petition, wherein the order of blacklisting was quashed, a shadow blacklisting was asked upon me. I was not allowed to participate in tender, and when with the intervention of this court, there was no stay. They lifted, I participated in the tender and emerged successful. They kept the matter pending just because of the pendency of the SLP before the Supreme Court, even though the law does not permit them to do that unless and until they obtain a stay order. But they continued to keep me out of the zone of consideration. And after the Supreme Court has dismissed the SLP, they have issued, which they have not brought on record, since they wanted to file a counter affidavit. I thought that they would be fair enough to bring it on record. Your Lordship may kindly see, this is a letter, a letter, a copy was, I have obtained at RTI. Lordship may see that. This is dated the 30th of April 25, wherein the Secretary to Government writes to the Chief Engineer, I am directed to invite reference to the subject stated above and to say that in pursuance of this department letter, this department...
That's a letter revoking the blacklisting.
Yes, my lord. So my lord, the consequence to that, my lord, is that once the blacklisting order goes, and I am the already selected tenderer, having qualified, having fulfilled all the criteria.
When that decision was taken, what was the date of that?
The decision was taken at a time when the matter was pending before the Supreme Court. Annexure 5, page. Quashed on 22nd of August 2023. I participated in this tender, which was floated in February 2023.
Blacklisting is 30th of June 2025.
2025, my lord. That order is
30th of April 2025.
My lord, that.
Now I am asking, before 30th of April 2025, what is the date of that particular resolution?
The resolution by yes, the additional affidavit. Yes, my lord. That was yes, my lord. I'll tell your lordship the date. The date is 26th of November 24.
26th.
November 24, when the matter was pending before in the Supreme Court. Now, well, it's just two judgments I'll place before your lordship.
They floated the tender or they have not floated the tender?
No, not floated. Not floated, and what is happening is whenever they are floating the tender again the base price goes up. Because of time lapse. This is, in fact, the second time the tender has been floated in respect to the very same work. Now, my lords, just two judgments I'll show to your lordships. The first one is, I don't tell you. This is 2022 Supreme Court. Just one paragraph, a few lines from one paragraph. I will not. The principle that needs to be adhered to in these kind of cases. Your lordships may take para 20. That is at page 9 of the judgment.
Yes.
Page 9 of the judgment, para 20. Your lordship got that? Twenty. 20. It's sorry, man. It's para 15, in which they have quoted para 20 of a 1986 judgment. I'm on that para 20 of the. That's at page. If your lordship takes page 9 of the judgment. This is Union of India versus Bharat Forge Limited. They have quoted 1986 Supreme Court. There, my lords, on the, there is thus no doubt. There is thus no doubt. Have you lordship got? May I read it out?
Yes, yes.
There is thus no doubt that the high courts in India exercising the jurisdiction under Article 226 have the power to issue a writ of mandamus or a writ in the nature of mandamus or to pass orders and give necessary direction where the government or the public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion mala fide or on irrelevant consideration, or by ignoring the relevant considerations and the material or relevant consideration material, or in such manner as to frustrate the object of conferring such discretion or policy for implementing which such discretion has been conferred. In all such cases and in any other fit and proper case, the High Court can, in exercise of jurisdiction under Article 226, issue a writ of mandamus or a writ in the nature of mandamus or pass orders and give directions to compel the performance of proper and lawful manner of discretion conferred upon the government or a public authority. And in the proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give directions which the government or the public authority should have passed or given had it properly and lawfully exercised its discretion.
Yes.
My humble submission to your lordships would be that once the order of blacklisting was quashed by this honorable court and there was no stay. No, my lords, they could not have cancelled that I will satisfy your lordship from the next judgment. But my submission before I come to the next judgment, my lords, that this action of cancellation was by itself on the face of it was wrong. No, I had not. I had participated after the blacklisting order was quashed by this honorable court.
I'm really using myself as a mouthpiece of the authority.
Sorry.
What is reflected from their.
Yes, my lords, yes.
Since you were a blacklisted, maybe the decisions are there, the matter is continuous. Since you were a blacklisted or a blacklisted contractor, so they decided scrap it date of rest value. Because the matter is pending in the Supreme Court. They were anticipating that the Supreme Court will appear and synthesize the intelligence order. They decided to classify on that source only. Now the question is that whether it can be taken as an exceptional case where
Yes,
we
Bharat.
don't have tax.
Yes, Bharat. That is exactly what I'm trying to canvass before your lordship. However, for that purpose, the next judgment which I want to show to your lordship is 2024, my lords, this Honorable Supreme Court. This also was a case where the tender was cancelled. Para 98 at page 39. Para 98, may I read, my lords? Thus, it is evident that the notice of cancellation dated 7/2/2023 issued to the appellant was at the behest of the concerned minister. Yes, Praveen. Yes.
If the statute or administrative instruction bestowed power upon a particular officer to take a decision, and this discretion will be left. If the exercise of discretion is stated or independent or any other extraneous factor, that is either from the
Minister or
command of the higher official
or a particular officer who is ill-disposed towards me.
The rubber seal officer, in this case also the minister says that you cancel it. So they have no other option but to cancel it. In those circumstances, the Supreme Court has said that this is independent application. Because you have not taken an independent exposure. If your decision is influenced by some of the external factors, I think that no decision I don't know. But here, the reason is wrong because the blacklisting was not there and you succeeded. The reason is reverse the order of this individual.
No, there is no reversal. The original writ petition was before the division bench. There was no reversal. So I succeeded at the first instance.
Second side, the order of the authority where you were blacklisted.
Yes, Madam.
So you according to you, the Supreme Court did not say the operation of.
Yes, Madam.
Or set aside that order. So whatever the reverse case remains operative.
Yes, Madam.
Their notion that you were a blacklisted and the matter is pending to go to the Supreme Court is not inconsistent. That is what you really wanted to say, that it was not proper because it was not blacklisted at that.
Correct, my lords. Not only that, and this, the continuance of me labeling me as a blacklisted contractor was an act purposefully made to keep me from carrying on my profession as a contractor. It was to ruin me financially. The agenda was to keep. Yes, madam. Exactly that they have succeeded in for the past more than 2 years, because your lordship knows that for a contractor to participate in any tender, he has to have a cut-off turnover in the preceding year. Now, here is a case where for past 2 years, I am not being allowed to do any work on the basis of an order which has already attained finality way back in 2024. And they continue to make me suffer on the basis of that. And that exactly is what the Supreme Court has said, in particularly this later judgment, that a state authority who is vested with such authority, state government which is vested with such authority, they have to act in a particular manner. They cannot ignore the orders of this honorable court. They cannot ignore the writ issued by this honorable court. And if their letter transpires that you obtain a stay. They do not obtain a stay. Pass, and even despite that, they write to the lawyer that you obtain a stay. No stay application is also moved before the Supreme Court. And on what ground had they blacklisted me, my lord? My lord was a party to that judgment. They had blacklisted because I was suffering from COVID. I had lost my eyesight. I could not even though I had succeeded in one tender, I could not submit my original documents. On that ground, I was blacklisted. Yes. Your Lordship sees this one judgment. I'll just show how the conduct has been for this case and what the Supreme Court has stated in this judgment. They have summarized all the points from paragraph 122 onwards of this judgment. May I read it? From the above discussion, we are of the considered opinion that the present list is nothing but a classic textbook case of an arbitrary and capricious exercise of power by the respondent to cancel the tender that was issued to the appellant on the basis of extraneous consideration and the behest of none other than the concerned minister in charge. There it was the minister in charge, here it is the officer concerned, the chief engineer. Before we...
The help of the decision.
Yes.
Like somebody.
No, it was a tender committee.
Is dictated by the chief engineer that you cancel.
No, it was the tender committee, and the tender committee which was to take a decision. The tender committee was influenced by the decision taken by the chief engineer.
Chief engineer was one of the constituent of the tender committee.
He was, I don't think, constituent of
He was part of the tender committee.
Chief engineer DPA roads. Principal Secretary of Government. Principal Secretary. Well,
everybody has a right to put these words.
My lords, true, my lords, but on the face of the judgment, a writ issued by this honorable court,
Dictated and commanded everybody to do it.
no, but this is a democratic body. This is an authority operating under certain rules and guidelines of the government, which is yes, ma'am.
From their conduct.
Yes, ma'am.
It may not be apparent, but it is really the conduct really reflects.
I have been victimized.
It has been to deprive you of your legitimate, the
Fundamental right, my lords, guaranteed under the Constitution.
cancellation is not a simple cancellation. But
That-
is some motive.
That is exactly my case. The cancellation.
Any other legal thing or arbitrary?
My lords, I can show their conduct from the various documents. I just wanted to. I believe I have put forth all my before your lordships. Yes, my lords, all my weapons, all the sufferance that I have been subjected to, I have put forth before your lordship. I leave it to your lordships now to deliver me from this sufferance.
With great respect to my lord senior pillar, the citations, the judgments my lord senior cited, citations are not given to us pillar. But let me kindly have the decisions my lord senior referred to, my lord. Citations are not given to us pillar. I have not. Yes, my lord. Then I am leaving the point of lord to your lordship. Now, my lord, lordship kindly come to page 8 of the writ petition. It's an amended writ petition. Originally, the prayer of the writ petition was to issue work order in favor of the contractor.
Because in the meantime, during the pendency, you are cancelled. They wanted to challenge the cancellation.
Now they are challenging the cancellation on 2 points. It is cancelled without giving them opportunity of hearing. Number one. Number two, it is cancelled without assigning any reason. And they are deriving their legal right from the point that they were stood L1 bidder. My lord, my humble submission to your lordship, subject to lordship appreciation, my lord. And they have prayed for issuance of mandamus. When only on the point that they stood L1 in the process, my lord, it doesn't create any legal right for them to claim that opportunity of hearing should be given to them before cancellation of the tender, my lord. Now, on this point, issuance of mandamus, writ of mandamus may not be appropriate. And the thing is, so far the arbitrariness is concerned, my lord, senior argued, my lord, it was not a decision of a particular person, my lord. But say kindly have a glance to Annexure A by 2 of our counter affidavit. It was a committee was constituted, 6 members were there in the committee. And this chief engineer was member in serial number 2. My lord. Yes. Now,
because the challenge of the order of land mistake. The order which was decided by the that means that they cannot be treated as a blacklisted object. You may have gone to the apex court, but the apex court did not pass any order of stay nor granted any interim order. So the order of the since the apex court gave a notice or directed the applicants to be filed. Yeah, yeah, the law, you know, because clarity is it not the unless the higher court stays its operation or passes certain on. That's it, because these are blacklisted, there's no legal. Since he approved the court and got that order of blacklisting set aside, obviously they do not, that was not piloted only.
Page 136. The bid for the work improvement such as widening and strengthening of Bhawanipatna Gunpur Kasipur Road in the district of Kalahandi under state plan invited by bid identification number so and so is hereby cancelled as instructed by Government Works Department by letter number so and so.
What is the earlier one? Yes, proceeding paragraph. You have read this article paragraph. Yes, before it, 4, 5 lines.
It's only one document.
No.
Annex of
minutes. That is the minute. Minute you have to read. I think this is the number 7.
Yes, that is in the affidavit dated 2/12/24. Their affidavit.
Who have to disclose this?
The chief engineer DPI Roads has recommended the second time lowest percentage rate lender of RAPS Infotech Private Limited Special Task Contractor amounting to rupees and so only excluding applicable GST less than the corresponding estimated cost put to tender as per SOR number 2022 for approval of the government as per para 6.3.5 notes 1 of the report.
Page, what is the page number?
That is actually the relevant page which I read out to your lordship is at page 20 of that affidavit, 21. 21 and 22 of that affidavit, of the additional affidavit filed by the state, 2/12/24. He's reading page 19. The relevant portion is at page 21 and 22.
As reported by the chief engineer, Odisha, the L1 bidder has satisfied the qualifying criteria for bid capacity. The tender was valid up to 26/4/2026. The tender was placed before the meeting of the tender committee held on 31/1/2023 at 11:30 AM for discussion. During discussion, the chief engineer WBP Odisha apprised the committee that as out of 3 numbers of technically qualified bidders, 2 bidders have quoted the bid amounting to rupees being 14.9999 less than the estimated cost put to tender. A transparent lottery was held on 4/1/2023 and Mahabir Infra Special Class Contractor was selected as L1 bidder. Besides, chief engineer
Where from you reading?
from the additional
Additional affidavit filed by the state government on 2/12/24. The tender committee proceedings begin at page flag H. The discussion begins at page 19. The relevant portion is at page 21. Paragraph beginning earlier the tender. Say page 2.
Yes.
Earlier, say sentence. Earlier.
Earlier, the tender was placed before the meeting of the tender committee of Works Department on the chairmanship of Principal Secretary. Works Department in the meeting.
Page 22. That is the class. The paragraph beginning with instant tender.
The instant tender was placed before the meeting of the tender committee Works Department under the chairmanship of Principal Secretary Works Department held on 24/10/2024 at 11 AM for discussion. During discussion, the committee observed that the L1 bidder in the instant case RAPS Infratech Private Limited Special Contractor was blacklisted by the department and the SLP related to the state blacklisting matter is under challenge by the state before the Honorable Supreme Court of India. Keeping in view the fact that the recommended L1 bidder, RAPS Infratech Limited Special Class Contractor, is a blacklisted contractor.
That blacklisting order was passed. You yourself has admitted.
Yes.
We are preferring a special day will not do. That you say.
SLP was filed on the.
How can it justify? You are in contempt at least. You do not know, they have not gone. If they were the blacklisted as we have treated them, then you are really defying the order of the concern. Of contempt you can, you will face. I was there. My brother was one of the members of that. Range.
I'm aware of that.
Sorry, sir. We are conscious. It is within your domain, within your discretion to cancel. It is been a simplest of cancellation. That because of these litigations, the purpose of this particular contract or a tender getting frustrated. So we don't know when the Supreme Court will hear out the matter or something like that. We have decided to start. Thank you, that. Appreciate it. Your reason is directly in conflict, contrary to the reason which you have. Then what in the law is that if it is stated with some kind of a marriage, because you still had a strong ill feeling about him that he's a blacklisted, I will not may see him. No. Any judgments you have, no support. And don't ask for the exam. Are you rating the result? No. Yes. What is the second one?
Second one, again, another tender, they blacklisted me. When I participated in the tender, they blacklisted me because SLP is pending in the Supreme Court. No, I didn't. Sorry, my lord, I am sorry. They technically disqualified me because I was a Supreme Court SLP was pending.
What is the scheme of this?
That has been stated by your lordship. Second one has been solved. Yes. By order dated 21/10/2020.
Item number 30. 35.
Yes, ma'am. 35, sir.
Just note that there is already a special bench for this matter.
No, my lord, previous clarification that is only concerned to CNC. That bench of Cuttack is only concerned within the municipal area. If it can be.
They can also.
Yes, subject to your, we have absolutely.
We are assigning this matter to that way.
Yes, my lord, in the meantime, slight development has taken place. Yesterday, supposedly the collector and the Tahsildar had gone there. They have made a field review of that area. So if they can also give a report, whatever their study or whatever they have observed, the government effort.
That suggestion would come, but the first and primary, which I think the object is to remove
the waterlogging. That is what my lord.
Make it
habitable for the people who are staying there.
Mr. Martha, yes, I have not minded that the Kotak Development Authority is being implemented as a party in this case, but in fact, Kotak Development Authority has absolutely no role.
Why it has gone to you? They were all uniform. It is beyond the scene.
No, that
I think the Cuttack Municipal Corporation, it is gone to CDA.
That it is within the Kotak Development Authority areas. So fact remains, Kotak Development Authority area is used for planning planning function being discharged by the Kotak Development Authority.
Then municipal this.
No, now my humble contention is that there are three type of development. I just got information I got yesterday. Their thinking that means waterlogging is occasioned because of something called obstruction in natural flow channels available to the particular area. That because of one reason, that is the development of the wide road that is being taken up by the PWD department or the other departments. The secondly, Panchayat Raj department and BDO, they have to take care of the development and all these things. Kotak Development Authority
is it within the Panchayat area?
Yes.
Yesterday also. How the CDA come?
The CBN has taken over. Development.
For the development planning, they have taken over one part, they say we will take care, the other part they will.
I am aware there also. There is a Kolkata Municipal Corporation.
Yes, sir.
There is a Kolkata Metropolitan.
Yes,
Development Authority, KMDA. How they react is a replica of it. Yes. I'm conscious.
So here, my lord.
Have to do it. You have every authority to do that.
Yes.
There is no difficulty.
Yes.
You have every authority to do that.
Yes,
And you are referring the matter, the benches.
Absolutely. So here in this case, my Gujarat Raj department is to react.
They are more.
They can have an overall view of the entirety of the issue also.
My brother has to go to there. So
In the meantime, waterlogging is there. You lordship may direct in the meantime.
we just go tomorrow.
That matter, this can be on the next sitting of that bench. It can be.
But in the civil.
What is this?
I am.
The rest of the matter will not. Rest of the matter.
Beg your pardon, Lordship. Lordship, I cannot 30 minutes.